This is what I want you to internalize. But for the fact that you were pulled over and arrested, you still be out there doing whatever you're doing, not reporting for probation. Where did you see this going? That you were just never going to report and everybody would forget about it?
No, ma'am.
The moment the camera pans across this courtroom, you can feel the weight in the air. Every seat is filled, every glance charged with tension. What's unfolding isn't just another legal hearing. It's a story about truth, reputation, and control. Both sides know this day could change everything. The defense looks confident but cautious, the prosecution calm yet focused. It's a silent duel of strategy and ego where every word and pause matters. As the judge prepares to begin, there's a collective hush. This isn't just law, it's human drama, live in motion, and the first word spoken will set the tone for everything to follow.
Zenaida
Luis Ray, can I have parties announce?
Rick Pena for the state of Texas.
Leland McCray on behalf of Miss Zenaida. Is it Ray, the last name?
Yes.
Yes, I thought I was pronouncing it. It's Miss Zenaida Ray.
And are you Miss Ray?
Yes, ma'am.
Did you review the documents entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney?
Yes, ma'am, I did.
Did you understand it?
Yes.
Are you the same Zenaida Luis Ray who was placed on deferred adjudication for the offense of injury to a child bodily injury by omission on October 20th, 2021 for a period of 10 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor, off of state's original motion to enter adjudication of guilt and revoke community supervision, a violation of condition number 4. In Bexar County, Texas, the defendant, Zenaida Luis Ray, did then and there fail to report to the supervision officer as directed for the months of October 2022, February, March, June, July, November, and December 2023, and violation of condition number 4.
How do you plead to that? True or not true?
Not true, Your Honor.
State.
On state's first amended motion to adjudicate.
I'm sorry, I missed her response. What was that?
True.
Okay, thank you.
Before we move forward, it's important to understand how much history stands behind this trial. What seems like a single day in court is actually the climax of months of legal wrangling, media debates, and emotional testimony. Each argument has been carefully rehearsed, every document dissected line by line. The attorneys on both sides know what's at stake. Not just a verdict, but their reputations and credibility. You'll notice how they control their tone, using formality as armor. This isn't just about justice anymore. It's about survival in front of a nation watching closely. Every phrase now carries the weight of a career.
Finally, Your Honor, violation condition number 4. In Bexar County, Texas, the defendant, Zenaida Luis Ray, did then and there fail to report to the supervision officer as directed for the months of January, February, March, April, May, June, July, August, and September 2025, and violation condition number 4.
How do you plead to that?
True, Your Honor.
State will waive the remaining violations on the original and the amended motion to adjudicate, Your Honor.
Any objection?
None.
All right, did you understand by pleading true to 4, the court could find it true, grant the motion, find you guilty, revoke, and sentence you up to 10 years in the prison?
Yes, Your Honor.
Knowing that, do you still wish to plead true
Yes,
to violation of condition 4, and 4?
yes, Your Honor.
Court will find 4, and 4 true. Is there a proposed agreement?
There is not, Your Honor. Both sides are going to open to the court with our recommendations.
All right, state, what are you requesting?
We are requesting that Your Honor revoke her probation, adjudicate her guilty, enter the affirmative finding of family violence, and sentence her to 10 years TDC.
All right, defense, what are you requesting?
Well, Your Honor, we're asking for her to be reinstated on probation with inpatient treatment. She tested positive a couple of times for marijuana, but at the moment, she's gotten some stable housing and a job from what I'm being told. I know she did not report, and the court takes that very seriously. I've spoken to her about it, but I think her life is just kind of all over the place still a little bit. Not stable housing, not steady employment. But I think her relationship with her mother has got a lot stronger, so she has more support now. And I would just ask for a chance to be reinstated, but again, would ask for some type of inpatient treatment.
All right, any objection to the court reviewing the court summary?
None.
State would also ask that you take those for notice of the court's file.
All right, any objection to the court taking judicial notice?
Here's where the beauty of legal performance shines through. Watch how the defense attorney raises an objection. Crisp, calm, without a hint of aggression. That's deliberate. In a courtroom, the most powerful voice isn't always the loudest one. Control equals credibility. These moments reveal who's truly experienced and who's scrambling under pressure. The judge listens carefully, expression unreadable, but every tone shift is noted. The prosecution, on the other hand, stays composed, not reacting too quickly, which signals confidence. It's a dance of intellect and restraint, where one misplaced emotion can undo hours of preparation. This is precision lawyering in its purest form.
Case.
It's a direct.
It's a manufactured delivery, small amount. My understanding, and maybe I've spoken more to one prosecutors, that upon the court's resolution of this, they were going to ask for that to be TIC.
That is correct, Your Honor. Once this is resolved, we'll take this case.
What is the alleged offense?
Mark?
Yeah, but the alleged offense is a manufacturing delivery of a controlled substance PG 14200. There is a co-defendant, however, in the way the drugs are found, there's only one bag attributable to this co-defendant. So I think once lab results do come in, which we haven't received, I do believe it will be a lesser degree.
All right, thank you. All right, anything you want to say? You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, what would you like to say?
Your Honor, I just wanted to say if I would be able to get another chance to turn my life around. My grandma did. I know she did have cancer.
Now, let me just tell you this. Your grandmother, did she just develop, when did she develop cancer?
It's already been 6 months. She's been going through treatment, and
so what have you been doing?
I've been working.
Listen closely to the change in tone right here. The witness hesitates. A pause. A flicker of uncertainty. That's all it takes for the prosecution to pounce. It's subtle, but in court, hesitation equals vulnerability. The defense knows this, and you can see the silent panic in their eyes. A witness losing composure can shift the entire perception of a case. That's why credibility is everything. This isn't just a test of truth. It's a test of control. And once emotion creeps into testimony, the balance of power tilts, not through evidence, but through human psychology. That's the hidden game behind every trial.
And then so is this the first motion to revoke?
Yes, Judge.
All right. I don't think you're a good candidate for probation. I mean, what have you done other than not report and pick up a new charge?
I was doing my classes, Your Honor.
Did you?
They kicked me out of bid. I was going to the one on Piper Lane.
Mhm.
It was twice in there. I was reporting it. I was using sympathy because of my seizures, and I did get my insurance to get back on Keppra. So I've been getting Keppra to control my seizures, and I haven't been using marijuana since.
But I mean, you haven't done anything. That's the problem. And you've been on probation, according to this, since 2021.
I thought, like I said, I thought I just had a warrant, and I just stayed. I don't really get in trouble. I stayed in my.
Now watch the judge. The face is neutral, the voice steady, but that silence, that's calculated. Judges reveal nothing because neutrality keeps power in their hands. Both attorneys are reading every blink, every gesture, trying to guess the mood behind that expressionless stare. This is courtroom strategy at its finest. When to speak, when to stop, when to wait. The defense subtly leans forward, trying to catch a reaction. The prosecution sits back, confident in the silence. It's a chessboard of words and posture, and at this stage, even the quiet moments decide the outcome. Power here isn't shouted, it's controlled.
To me, they still try to reach out to me.
So you're saying these were not your children?
They were not my children. I'm not. I have no idea where they're at. I mean, through Facebook, they do still try to communicate with me, but I stay away because that was one of the conditions to stay away from the dad and the children.
Mhm.
Your Honor,
So,
just really quickly there, the recommendation from probation was for cognitive track with ISF and then follow up with inpatient, which I certainly think she could appreciate, would benefit from.
I mean, I understand that, but sometimes I don't agree with what probation is recommending. She's been missing for a long time. And the only thing that she's done, and I'm not taking the drug case as true, I don't know any facts of that, but the only thing you've done is disappear and pick up a new case. I just don't think she is a good candidate for probation.
Well,
And I'm not considering the other violations that are alleged in the motion because they were waived, but she's been missing for years. When's the last time you reported?
when I was in Atacosa,
And when was that? What year?
Your Honor, I don't even remember the year when I got out of Atacosa when I came back to San Antonio with my family. Like I said, I was in an abusive relationship using, and I came over here.
This is where the tide begins to turn. A seemingly ordinary question lands like a punch. It's not what's asked, it's how it's framed. The witness freezes, the defense looks uneasy, and the audience can sense something shifting. This isn't luck. It's legal craftsmanship. The prosecutor has built up to this moment for hours, setting the trap piece by piece. Now the hesitation is proof, not of guilt, but of doubt. In the world of law, doubt can be deadly. You can almost hear the silence stretch, heavy and telling. One question. That's all it takes to rewrite the momentum of a case.
The court's attention. I just from what I've seen over time is that a lot of times people come into the system because of a case, and they have a lot of other issues with their life, right? And they're not well positioned to take on the responsibility of probation, even though they fully understand the consequences of not doing so. And I think that's where we kind of find ourselves at now, where she's in a better spot, both financially and with her job and with her family. I think to maybe grab onto probation and I guess maybe take it in the right direction to be able to fulfill its obligations more precisely and consistently, which I think she has not done. And I know the court's picked on, she's done nothing. But again, she was put into probation, I think, asked for a level of accountability. I think she needs some more support at that time. I know the court makes itself available for those things. But she, I think, just has some particular needs that needed to be addressed in that work. And I just asked the court to take that into consideration in fashioning a sentence. Again, we're asking for cognitive track and inpatient treatment.
And how old are you?
I'm 30.
All right. So here's the thing. It's not as though you're 17, right?
Right.
And how did you
Every move from here on is deliberate. The defense tries to recover, quickly redirecting the narrative, but the jury's eyes have already shifted. It's in these fragile moments that the skill of a lawyer truly shows. The best don't panic, they adapt. They reframe the story before it breaks apart. You can see both teams mentally calculating what to say next, what to avoid, what to emphasize. This is no longer about facts. It's about framing those facts persuasively. The atmosphere has changed. You can feel the pulse of tension now, steady, slow, and dangerous. One wrong word could shatter everything.
that you were pulled over and arrested, you still be out there doing whatever you're doing, not reporting for probation. Where did you see this going? That you were just never going to report and everybody would forget about it?
No, ma'am.
Then what were you expecting to happen?
I knew I was gonna get caught, and I know I had to come and do it. I had to do it. Yes, ma'am.
Right. So you were expecting someone to catch you. You were not planning on turning yourself in.
No, I was gonna turn myself in.
When?
The whole thing. Well, like I said, Your Honor, my grandma has cancer. So my grandma was like my mom that raised me. And I mean, I was out there helping my grandma, staying with my grandma.
I don't think you're a good candidate. You've been on probation since 2021. The only reason why you're here before me today is because you got pulled over. Otherwise, we never would have seen you. So I just don't think you're a good candidate. And I'm going to grant the motion. And I'll note for, the state did not want you to have deferred adjudication. You were given deferred adjudication to try to get your life together. The court is going to grant the motion.
As the hearing nears its final stretch, exhaustion sets in, but so does determination. Every question, every objection now carries emotional weight. The judge's patience thins. The attorneys push harder. It's a battle of endurance as much as intellect. The defense relies on calm repetition to rebuild trust. The prosecution sharpens each statement to pierce through doubt. The witness, visibly drained, still tries to hold composure. You can sense that the end is near, but no one's sure how it will fall. This is the moment when truth and performance collide, and neither side can afford to blink.
Two, so we would ask for a 3 to 4 year sentence. I don't think her priors are that bad, and the state has already acknowledged that this new case is. The court hasn't heard it as true, but I think I appreciate the candor, at least saying, "Hey, it's a minimum amount of drugs. We're going to reduce the charge if it was to go forward, and they're willing to TIC it."
All right. The court is going to, as previously stated, find 4 and 4 true. Find you guilty, revoke. There's to be no residing in any household with minors. There's to be no unsupervised contact with minors.
That did not show that it was.
All right. There's an affirmative finding of family violence, and there's $100 restitution to an approved family violence center. And the court will sentence you to 6 years in the prison. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it?
Yes.
All right. You have a limited right to appeal. That right to appeal is as it relates in the allegation in the motion, not the fact that you were on deferred adjudication. Because this is an affirmative finding of family violence, and because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right. And I'll request the therapeutic community counsel. All right. Good luck to you.
And that's with all back time, Judge.
And just like that, it's over. The gavel drops, and with it, weeks of preparation, strategy, and emotion come to an end. What we've witnessed isn't just a courtroom battle, it's a reflection of how justice truly operates. Unpredictable, human, and deeply psychological. No matter which side you support, the story here is one of skill, pressure, and perseverance. Every expression, every silence had meaning. If this case proved anything, it's that the truth in court isn't always about facts. It's about who presents them best. Stay tuned for more breakdowns like this, and don't forget to subscribe, because the next case might be even more explosive.